questions I receive as a DUI attorney is, how can I fight my DUI case? Well, there's several different ways you can fight your DUI case. For example, you can attack the stop. Now, what happens here is, let's say police pull you over for speeding, and they were actually wrong. It was actually a different vehicle that was speeding, but they pulled you over anyways. And at that point in time, you had committed no traffic infraction at all. Well, that would mean that if you are subsequently arrested for and charged with a DUI, that means the stop was bad. If the stop was bad, that means that you had a Fourth Amendment violation, because as a citizen, you are allowed under the Fourth Amendment to be free of unlawful searches and seizures. If police pull you over unlawfully or pull you over by mistake, then at that point, your Fourth Amendment rights have been violated. Now, in California, when you have a Fourth Amendment violation case for your DUI, the way and the avenue to attack that is under Penal Code Section 1538.5, known as a motion to suppress. Now, in the scenario I just gave you from speeding, if it's found that you were not actually speeding and you were therefore not lawfully pulled over, what that would mean is everything that happened after your stop would be thrown out of court, because the stop was illegal, and subsequently your DUI case would then be dismissed. Another common defense to a DUI charge is that there's insufficient evidence to prove that you are guilty of the crime. Now, this could be, for example, if a DUI call is made and when police arrive, there's no admission of driving, there's no witnesses to driving, and it's not even the person's car who's standing there. In that situation, it would be very hard to prove that this person who was under the influence was actually drunk at the time, or that they were even driving the vehicle, unless they were to make some kind of statement admitting they were driving. Another common use of insufficient evidence can be in a circumstance where your blood alcohol level is not actually the 0.08 requirement under Vehicle Code Section 23152 subsection B. Now, in that case, if your blood alcohol level is below the legal limit, then in that charge, there would be insufficient evidence to prove you guilty of that violation of law. There are many different ways you can fight a DUI case outside of just what I've listed here in this video. That is why hiring and having a very good and experienced DUI attorney can be the difference between you receiving a DUI conviction or having your case dismissed entirely. Call the Inland Empire Criminal Defense today, and I can help you.